Hello, my name is Shari, and I'm here today because my privacy rights were violated by my place of business and where I am also a patient and was scheduled to receive surgery. My patient health information was disclosed without my permission to the supervisor that contains all my personal information, such as social security number, age, place of residence, insurance and pay information, along with my medical data that included former surgeries, former and current medications, past medical conditions, personal psychological conditions, and other pertinent health information. I'm suing Ashford Hospital on the grounds of negligence. Negligence is the idea that someone had a duty to someone else, the duty was breached, and the breach caused harm. Claims that are brought under some sort of negligence are violation of privacy or an invasion of privacy. HIPAA does not provide a privacy right action, and when it comes to HIPAA violations, the individual is restricted to filing complaints with proper governmental agencies. So in addition to this lawsuit, I have filed a complaint with the United States Department of Health and Human Services Office for Civil Rights. Ashford Hospital was negligent when handling my patient health information and consequently must be held liable for damages. Ashford Hospital violated HIPAA by disclosing my medical records when they have a legal responsibility to protect and avoid deliberate or involuntary misuse or disclosure. My information was sent via email intended for the operating room team only. In some way, my information was also sent to a supervisor who is not part of the operating room team, but a senior administrator within the facility, and there could be a possible violation of confidentiality and discrimination based on my medical history. Ashford Hospital did not take any appropriate administrative, technical, and physical safeguards to protect the security of my PHI. HIPAA and emails can coexist, however, there is a possibility of a security breach. Under the HIPAA law, I understand that I'm not required to give permission for disclosure to another healthcare provider for treatment. However, my records are to be kept confidential and should not be shared with anyone unless it's a court order or a signed release. Furthermore, the privacy rule protects my medical records even when I'm a patient of the provider. The privacy rule is intended to provide strict legal protection to ensure the privacy of patient health information, and it protects all protected health information, including individually identifiable health or mental health information held or transmitted by a covered entity in the format including electronic, paper, or oral statements, which Ashford Hospital violated. In regards to the mental health information, there are firm privacy laws concerning the unacceptable release of a person's mental health information. HIPAA regulations dictate that entities stay in compliance when it comes to mental health records. HIPAA does not separate mental health records and the PHIs. The privacy rule is intended to keep all PHIs protected. However, HIPAA conditions do imply that there are unique matters concerning psychotherapy records. Psychotherapy records are treated in a different way from other mental health information since they contain intensely delicate material and because they are the personal reports of the psychotherapist that usually are not necessary or of assistance for treatment, payment, or healthcare operation reasons, other than by the mental health specialist who provided the notes. Psychotherapy notes should always be kept secure and separate from medical and billing records. Ashford Hospital failed to do this, which can result in significant harm to the person and the hospital in the form of increased civil penalties and possible criminal penalties. In addition, a covered entity must obtain a patient's consent prior to releasing psychotherapy notes for any purpose. Healthcare ethics is an essential duty of any healthcare organization, and adhering to an ethical code is an imperative duty of a healthcare organization's obligation. Ethics are the common beliefs of right and wrong as opposed to guidelines of the law. We live in an information-hungry society. Additional care must be taken with information furnished in faith by patients. Emotional stories occur in relation to people's lives being ruined by infringers of health information confidentiality. Taking further procedures to keep patient information safe would come more simply if we supported the role of guardian. Every healthcare professional has a responsibility to perform in ways that will cultivate trust, loyalty, and regard within the organization and the people they serve. Healthcare professionals should promote an organization that not only delivers superior healthcare, nevertheless upholds the ethical conducts and manner of the organization. By upholding these responsibilities and adhering to ethical principles, healthcare professionals are fulfilling the healthcare organization's missions, visions, and values. In conclusion, Ashford Hospital committed HIPAA violations of the privacy rule that disclosed my PHI, including my mental health records, on the grounds of neglect by not securing my personal and private health information to an unauthorized person without my consent that can potentially cause discrimination, stigma, and harm to a person, and legal ramifications to the hospital because of the breach of sensitive and private information. Healthcare organizations need to strengthen their training efforts for all. There is frankly no explanation for any healthcare organization not to be absolutely educated in conformity with HIPAA law, since if they are found non-compliant, the Health and Human Services will not acknowledge the lack of knowledge of the law as justification.